Hi, everyone, and welcome back to the Jamonet module on European and international environmental law. We're here for a new webinar of our EIEL webinar series. With me, Professor Riccardo Pavoni, the academic coordinator of the Jamonet module, and our speaker today, Alessandro Monti, assistant professor at the University of Copenhagen, who will be presenting today his new book, and of course discussing the topics that he addressed there. But for more on that, I will give the floor to Professor Riccardo Pavoni for an introduction, for a more extensive introduction of our speaker. Riccardo, the floor is yours.
Yes, very short introduction because we don't want to steal time from our speaker. Perhaps we would like to recall, Dario, that this is going to be our last webinar in our series. So after this, we will have a final event on the 27th and 28th of November. We will have a conference, a final conference for our Jamonet module. We will circulate news and program in the next few weeks. We are pretty excited by that event, and we have surprises. We have big names, and you will see this news coming up over the internet and over our social channels. As far as today, there wouldn't be any better way to complete our webinar season than having Alessandro Monti with us today. We are particularly happy to have him here because he has written a very relevant monograph when it comes to the themes of our Jamonet module. As Dario said, the name of his book, the title of his book is Promoting Renewable Energy, the Mutual Supportiveness of Climate and Trade Law. The book was published by Elgar Publishing this year, so it's a very recent book. That's why we are talking about a book launch in a way. And this was a very good opportunity for me to read this book, actually, and that's what I've done in the past few weeks. And I thought it was a very rewarding reading. I really learned a lot, and I don't want to say much about the book. Let me just, let's say, underline three preliminary points or remarks about the book. First of all, I appreciated very, very much the clarity of the book. I think that the style in which the book is written is completely understandable. Even if you are not a trade law expert, you will be able to grasp and understand the points made by Alessandro. So this is really a merit because, as everybody knows, sometimes trade law and economic law can be very, very technical, very complex in a way. So this effort that Alessandro has made in his book to simplify these topics is really remarkable in my view. And the second consideration is that Alessandro, of course, is not ignoring the economic aspects of these issues. But in the book, I find that there is a very wise and nice combination of economic analysis and legal analysis. Of course, these legal topics cannot be fully understood without any knowledge of the underlying economic scenarios or economic realities. So I think that this is really another merit of the book. And also, of course, let me also say that this is not merely a description of the state of the law here. The book contains a nice combination of a descriptive approach to this issue, underlying the issues, the applicable legal frameworks, and continuously there are personal reflections and comments and conclusions by the author. So this is really a remarkable piece of work in my view, and so we are very particularly glad to have Alessandro here. I don't want to say much about his biography. Dario has already said that Alessandro Monti is an assistant professor at the University of Copenhagen at the Faculty of Law. Is actually, as perhaps as his name may suggest, of course, is one of, let's say, is involved in the phenomenon that we call the i cervelli in fuga, the brain drain, which is affecting and hitting Italy since many years. Actually, Dario Piselli is also another example of brain drain. So two Italian, international and European lawyers who have fled Italy in a way and are based somewhere else. So our hope is that one day you will rethink your decision and you will find a way to join our Italian Italy and Italian academia or Italian professional circles. The book is based on his PhD. His PhD was completed recently. It's actually a double degree PhD, which was conducted, which has been awarded by the universities of Innsbruck and Padova. And then the monograph, of course, is an extension and is revisiting his PhD. So, Alessandro, the floor is yours. Thanks for being with us today.
Thank you very much, Riccardo and Dario, for the very kind introduction and already the kind words about the book. I would just like to say that for me, it's really a privilege, an honor, and a pleasure to be here today in this webinar, even more so learning that it's the last webinar of the series. So I'm very glad to be here, and congratulations also for arranging all of this, because I think even in the post-COVID era, it's still very relevant and very important to have webinars that can reach a very broad community, that can be streamed anytime. And so I'm very happy to contribute to your module and to your series. And without further ado, I think I'm now going to share my screen. So just 1 second that I will open the slides. Okay, so it works. Perfect. So now I will begin with the actual presentation of my book, which is entitled Promoting Renewable Energy, the Mutual Supportiveness of Climate and Trade Law. And as Riccardo was mentioning, the book has been published in May by Elgar, so it's very recent. And the book briefly addresses, of course, the topic of renewable energy and how it relates to climate and trade law. So what I'm going to do today, I will first of all give a bit of a background to this book and explain how I came to this topic and what is its relevance today. Then I will explain the analytical framework that I adopted in this analysis and delve into the complexities of the interaction between climate and trade law for the promotion of renewable energy. And I'll do that also with some case studies on trade disputes that have targeted specifically renewable energy technologies. And lastly, I will conclude by pointing out some of the main contributions of this book and sketching a way forward on how this interaction between climate and trade law can actually become more mutually supportive. So in terms of background, I would like to begin by stating that the energy sector, as it's well known, is the largest contributor to anthropogenic greenhouse gas emissions. So when we think about climate change, the connection to fossil fuels, to energy sources that pollute, that contribute to an increase of emissions is quite immediate. And there are estimates from, for example, the International Energy Agency and other international bodies showing that way above 50% of global emissions are related to fossil fuels. And the generation of electricity, especially from sources like coal or gas, let alone oil and other heavy fuels for shipping, aviation. These are all really big contributors to the climate change phenomenon. And against this background, when we think about the international climate change regime, which has evolved from the United Nations Framework Convention on Climate Change from 1992 all the way to the Paris Agreement of 2015, and even beyond with, for example, the Glasgow Climate Pact, all these instruments have made progress, but they are not yet sufficient to fully address energy emissions. Essentially, there is not enough legally binding obligations in these legal instruments to tackle emissions effectively. This entails that, at least at the international level, there is a need for interaction with other areas of international law. And I say this because, of course, there is also the sphere of domestic law, and national jurisdictions, national courts have been very much at the forefront of tackling climate change with the adoption of, for example, climate neutrality targets in many countries, and also progress in climate litigation, which has taken place in many countries, and also very recently before the European Court of Human Rights. And just yesterday, there was one of the biggest hearings on the Portuguese climate case. So these are developments that are happening in many areas, and they go above and beyond just the climate change regime. And there is a crucial role, in my personal view, which is shared by several legal scholars and other commentators, that the trade regime in particular plays a great role to support the green transition, to support climate change policies, and to promote green energy. At the same time, there is also a risk that international economic law at large, including both trade law and investment law, can serve as an obstacle and can potentially harm this development of climate change policies. And some other projects that have been conducted recently also look into international investment law, for instance, and the whole debate on the Energy Charter Treaty and other international investment agreements, which are protecting fossil fuels and other investments that are non-consistent with the Paris Agreement, and potentially delaying the achievement of the temperature goals. So interaction between climate change and economic law broadly is crucial. And the way in which I approach this interaction and I look at it in my work is that of taking into account the idea of mutual supportiveness of climate and trade law. And I would like to say at this point that this idea of mutual supportiveness has roots in legal academia, which date way earlier than my PhD thesis that then became my monograph. And in fact, Professor Riccardo Pavoni was a very influential author who published in the European Journal of International Law a few years earlier on this very concept of mutual supportiveness, and it's been very inspirational, along with some other readings on the development of mutual supportiveness. The question is, why is mutual supportiveness so important when we look at climate and trade law specifically? And one of the reasons is that these two regimes have developed largely separately, and they have different objectives, because one regime, the climate change regime, pursues goals such as stabilizing the amount of greenhouse gas emissions in the atmosphere, and that's what we find in the UNFCCC of 1992, and also pursuing temperature reduction goals in the Paris Agreement. Whereas the trade regime, which developed much earlier than the climate regime, it's largely aimed by the objective of increasing trade liberalization. So ensuring that there is more openness in international trade. And we will get back to this with some specific provisions, but essentially what I would like to say at this stage is that neither of the two regimes, while pursuing different objectives, is entirely hostile or closed towards the others. Because in fact, in the UNFCCC, so in the climate change regime, we find specific references to openness, to trade, and in the WTO agreement establishing the World Trade Organization, we find references to the sustainable development and the pursuit of environmental goals, so goals that are not just trade related. The idea of mutual supportiveness in this context comes more generally from the fragmentation of international law, and it has been proposed, as opposed to some other theories, as a way to reconcile the objectives that are pursued under each treaty regime in both law interpretation and lawmaking. So different regimes like climate and trade law can have very different goals, and mutual supportiveness is something that looks at making those goals not collide but interact and support each other. And I will go a bit more in depth on the phenomenon of fragmentation of international law, just to explain how mutual supportiveness is an innovative and perhaps more refined way to deal with this issue. The fragmentation of international law, of course, is a phenomenon with deeper roots, which dates back from the development of the field in the 20th century. And in the early 2000s, the International Law Commission established or published a report on the phenomenon of fragmentation, which largely relied on the Vienna Convention on the Law of Treaties to solve norm conflicts. And among the various techniques that are pointed out in that report, one of the main ways to ensure that different treaty regimes are supporting each other, are integrating each other, is that of systemic integration, which is laid out under Article 31.3c of the Vienna Convention. And it is a very important tool for the international lawyer, but it does have a number of limitations because it has been applied in a number of disputes, such as the panel in the EC biotech dispute before the WTO, as something that requires parallel membership of the parties in the applicable treaties, and that causes some issues when perhaps one of the treaties has not been ratified by all the parties. And also another challenge here is that it's rather limited to treaty interpretation because it's a tool to interpret international agreements. And it doesn't really take into account the dimension of lawmaking. So this more proactive dimension of ensuring that treaty regimes develop consistently with each other. So mutual supportiveness essentially adds something to this concept, and to explain better the way in which it is applied to trade and climate, I will now briefly show the provisions that are relevant in, for example, international climate change law. So Article 3.5, which openly calls for the promotion of a supportive and open international economic system. So affirming that measures taken to combat climate change, including unilateral ones, should not constitute a means of arbitrary or unjustifiable discrimination or a disguised restriction on international trade. Essentially, the climate change regime, differently from some other environmental agreements, is taking a clear stance towards openness of trade. And this is confirmed also later on in the Kyoto Protocol, which also supports the need to minimize adverse effects on international trade. And in the Paris Agreement, in fact, we don't really have a mention of trade as such, so we don't find any provision recalling trade. But if we look at the NDCs, which are the nationally determined contributions that have been advanced by the parties to the Paris Agreement, we do notice that a wide range of them recalls trade-related measures on several different areas, ranging from fossil fuel subsidies to renewable energy subsidies to standards to border carbon adjustment. So we have voluntary commitments that are trade-related in what parties to the Paris Agreement have pledged to do for climate action. So trade is really inside the UNFCCC regime, and this is reinforced even more by recent developments. So the next conference of the parties, which is taking place in just a bit more than a month from now in the United Arab Emirates, it will actually feature a much greater role of trade with a more stronger presence also of the international trade community. So there are increasing interactions between these two different areas. And if we look at trade law and, broadly speaking, sustainable development, we can easily spot the progression of this discipline from the very first international agreement on tariffs and trade, which was adopted in 1947, and it called for the full use of the resources of the world and expanding the production and exchange of goods. So no a limitation at all in terms of the potential harm of this, to the WTO agreement of 1995, which instead recalls the need for an optimal use of the world's resources in accordance with sustainable development, seeking both to protect and preserve the environment. So the environment becomes an integral part of the WTO, and mutual supportiveness is not in itself in the WTO agreements, but we find it in several ministerial declarations, for instance, the one adopted in Doha in 2001, which affirms that the protection of the environment and the promotion of sustainable development can and must be mutually supportive. Then we find also in some other later documents this idea of open international economic system and protection of the environment as being something that should go hand in hand. And this is very good in theory, and it sounds very nicely, but now what I wanted to investigate with my book is what does it mean in practice? So if we look at specific areas, specific sectors, how does this mutual supportiveness translate and what can it offer? And I chose renewable energy as a topic to delve into because, first of all, it's characterized by a lack of specific provisions in either regime, because surprisingly enough, the climate change regime is not explicitly calling for a growth of renewable energy because of the way the agreements are structured. They're rather focusing on emissions generally than not specific sectors, also out of political considerations that informed the negotiations. And in the international trade regime, for different reasons, energy is not directly regulated because for a long time, trade in energy was taking place outside the GATT and the WTO, and it was not really needed that international trade law addresses the energy sector. But while we have this silence on energy, at the same time, both regimes are really very relevant for the promotion of renewable energy and for the energy transition, generally speaking. And all of this came to the front in the early 2010s, when for the first time, a number of international disputes have been brought before the WTO on specifically energy and renewable energy. So until that time, while renewable energy technologies were very incipient and not so much developed, there haven't been many disputes on energy. But now, with a growth of renewables, suddenly there were several disputes that were targeting renewable energy policies. And this is a new development that also really represented a way to look at the mutual supportiveness of climate and trade law in practice. And to give a bit of the overview of these disputes that I analyze as case studies in my book, they actually represent, as I mentioned, a new phenomenon. And they were concentrated in a very few years when, in a way, countries have been suing each other mutually, and they have been finding incompatibilities with international trade law in the respective schemes for the promotion of renewable energy. And I classify these disputes in two main categories. On one side are disputes that deal with discriminatory subsidies, and on the other side are disputes related to unilateral trade remedies. So in a nutshell, the first category of disputes relates to the issues of national treatment and to the issues of prohibited or actionable subsidies. And within this category, we see the very first dispute that was brought against Canada for renewable energy policies in Ontario. And then this has been followed by disputes against India and against the United States. And essentially, these disputes had to deal with something called local content requirements. So these requirements that were attached by countries to renewable energy support schemes, and they were calling for minimum percentage of products that are produced locally in order to benefit from the grants. And in economic theory, there are different approaches to local content requirements. Some scholars are more positive and underline that this may support the growth of local industries, and some others are more skeptical, and they affirm that local content requirements are overall not a good idea when we look at technology-wide developments, because while they may support a local industry, at the same time they impede a broader circulation of the technologies that could increase competition and bring down prices. And in a phase like the early developments of renewable energies in the early 2010s, probably it was quite important to have as much competition as possible and to have, in a way, an open circulation of these technologies so that they can become more competitive against fossil fuels, which are otherwise the solution adopted by states. And in this connection, the disputes that have been raised here, they were in a way supporting the development of climate policies, because it's not that international disputes before the WTO were targeting renewable energy schemes per se. The challenge was more that these schemes were designed in a protectionist manner that was not really supportive of broader international development of the technology. And pretty much all these disputes were decided in favor of the claimants. So it was in fact found that the different schemes represented a violation of national treatment provisions under Article 3 of the GATT and under Article 2.1 of the TRIMS agreement. And at the same time, there were no clear rulings on the legal nature of these subsidies. And in fact, the panel and the appellate body in Canada, Renewable Energy, carefully refrained from taking a position on the nature of those subsidies, because they essentially ruled that the market was not, there was not real comparable market between renewable energy and other energy sources at that time, so it was not possible to make a full assessment on the legal nature of that subsidy. And this has to date remained one of the big gray areas where international trade law still needs to develop and to show to what extent green subsidies are something that can be supported, can be compatible with trade rules. And just as a side note, maybe it's worth mentioning that these developments on subsidies perhaps are becoming a bit less relevant for certain technologies, for example, solar and even offshore wind in certain countries where the technologies are now more mature and there is less need to subsidize them. And if we look at Denmark, for instance, there are now auctions for offshore wind that are completely subsidy-free. But nevertheless, subsidies will still remain relevant. Green industrial policies will remain a way in which states will advance on a number of emerging technologies. And if we think about the development of energy storage solutions, if we think about green hydrogen, power to X, and all the other more emerging technologies, it's quite clear that public support will still be needed. So potentially there will be, again, similar issues under international trade rules. The other type of disputes that I analyze are those on trade remedies, which comprehend anti-dumping duties, countervailing duties, and safeguard measures. And in this case, the way in which these duties are imposed is more unilateral. So WTO members can decide by themselves that they think a foreign technology is being subsidized, is receiving an unfair advantage, and therefore apply one of these duties. But the way in which this has been challenged is that there are certain rules in the relevant agreements on how the subsidy and dumping margins are calculated, on avoiding the imposition of double remedies. And all these remedies have been applied on a number of different renewable energy technologies, from solar to biofuels. And there have been rulings showing that the way in which the unilateral remedies were applied was essentially in violation of WTO rules, and that once again, WTO members acted in a protectionist manner to protect their own industries by applying high duties on foreign technologies. So in this case, there are margins for improvement if we think about the broad discretion for WTO members to apply duties that make green technologies more expensive, because these rules, they don't really take into account to what extent certain technologies are beneficial for other sustainable development goals, such as the promotion of climate policies, but they are just neutral in terms of technology, and this might be on the long run a bit of an issue and an area where mutual supportiveness of climate and trade law requires a better coordination between the two disciplines. So without taking too much longer now, I will just move on to a number of solutions, proposals, and ideas that partly I talk about also in my book on how this mutual supportiveness of climate and trade law can be enhanced. And first of all, it's important to look at the multilateral level. And the multilateral level, meaning the WTO agreements, there has been some progress in the last years, but rather slow, although in recent times, there is a bit of a new momentum on bringing forward climate policies also within the WTO. And in this context, there is an increasing role played by specialized bodies, such as the Committee on Trade and Environment, as well as the newly established Trade and Environmental Sustainability Structured Discussions, which are more active in addressing specifically climate challenges. If we think about issues of subsidies or even border carbon adjustment, these are discussions that are conducted also within the WTO. It's a forum where members can have a dialogue, and at least at the informal level, this is progressing in a certain way. At the same time, we have a lack of progress in terms of legal reform, of amending WTO agreements, which appears rather difficult in the short term because a bit similar to the climate change regime, also in international trade law, we have a broad spectrum of countries, and the divide between especially developed and developing countries is rather pronounced. And this means that it's difficult to find consensus on adopting new rules. So there have been a number of initiatives taking place within the WTO. One of these that I've been recently involved in is called the Remaking Trade for a Sustainable Future project. And this has led to a number of policy recommendations to be for especially the upcoming ministerial conference in 2024, MC13, which can be seen as an opportunity to reaffirm the contribution of the trade system to a net zero future. And there are many ways in which this could happen, from just adoption of goals for net zero also within the WTO membership, to more stronger and more specific interventions on the subsidy rules. And recent legal literature here has really proposed new ways in which subsidies can be redesigned to make sure that green subsidies, positive subsidies, subsidies for sustainable development receive a preferential treatment in a way than brown subsidies that should instead be phased out. But again, these multilateral developments are important, but are a bit more long-term. What we see instead in the more immediate term is developments at the level of plurilateral and bilateral agreements. Plurilateral in WTO jargon means agreements that are not within the full WTO membership, but only among certain parties. And bilateral agreements, of course, are on a one-to-one basis. And both have been characterized by important developments recently. And these include also an incorporation of specific provisions on climate change in numerous free trade agreements, or FTAs. For example, if we look at the European Union agreements with a number of third countries, there has been an inclusion of chapters on environmental goods and specifically also renewable energy technologies. Agreements with Vietnam and Singapore that have been concluded or more than 5 years ago, actually, by the European Union. They tackle specifically issues of non-tariff barriers on renewable energy technologies, which are pretty much the same issues of local content requirements that were also targeted at the multilateral level. And another important development here is also considering climate change generally as an essential element in certain free trade agreements. And here, for instance, the EU-UK Trade and Cooperation Agreement was one of the first to call climate change an essential element, and in introducing mechanisms that can lead to the withdrawal and termination of the agreement if certain clauses on climate change are violated. It is, of course, difficult to imagine how this would play out in practice, but it is already a big step forward in terms of mutual supportiveness, the way in which climate change considerations are entering these FTAs and more plurilateral agreements. So, bottom line is that mutual supportiveness is being pretty much developed and enhanced in a wide range of FTAs. Of course, there are still many of these agreements that are older, that do not feature this type of developments, but in the recent ones, at least, it's increasingly present. And just coming to a conclusion, ultimately, on the book, I would like just to recap what the book does and what have been the main contributions. Is an analysis of the interactions between the climate and trade law regimes for the promotion of renewable energy. So both generally how these two legal regimes have evolved, and more specifically how this has implications for renewable energy. Secondly, it conceptualizes mutual supportiveness as a concept informing such interactions, and it is still a bit unclear from an international law perspective what is the role of mutual supportiveness, because it is not really, it doesn't feature in, for instance, the Vienna Convention on the Law of Treaties. So it is not a legal principle like systemic integration, but it is an emerging concept and principle that can play a role in especially interactions between regimes that are not characterized by a normative clash. Because if we look at the disputes that I mentioned before, it is not a matter of climate provisions being inconsistent with trade provisions, because, as I mentioned, neither of the two regimes regulates renewable energy. Therefore, there is not a clash, but it's rather a way of making sure that the existing principles and objectives of the regimes develop in a way that is compatible and that is consistent with each other. And thirdly, as I mentioned briefly, identify a number of possible options and legal developments that are taking place in which the synergies between the two legal regimes can be enhanced. And this applies to the promotion of renewable energy, of course, but also beyond, and talking about climate policies and trade law, right now, CBAM is, for instance, one of the big items on the agenda after the adoption of the first CBAM regulation by the European Union. And in terms of sustainable development more broadly, there are fishery subsidies that have recently been tackled by the WTO with a new agreement. There are challenges of circular economy and many other green sectors, so to say, that require plastics, among others, that require a good coordination between trade, environmental, and climate policies. And on this note, I think I will conclude my presentation, and thank you so much for your attention. And I will now also stop sharing my screen. Yes.
Perfect. Thank you very much, Alessandro, for the very exhaustive presentation, which really covers really well also many of the aspects that you touch in your book. Now it is the time to start asking questions using the chat function in this YouTube live webinar. So please feel free to do so. In the meantime, we will start, I guess, with some observations and comments and questions from Riccardo. So I'll give the floor to him first.
Thank you so much, Alessandro, for your presentation. Also, orally was very clear to me, so that is always something that I'm looking for, clarity. And I think that we are really having a very clear presentation here. My remark is about mutual supportiveness, because, as you said, I've investigated this issue very much in the past, and I'm very happy that you, in a way, took some inspiration from that article in the European Journal, which I published in 2010. Yeah, you're right. I mean, there are some, tensions here when it comes to how to conceptualize this tool, how to conceptualize this notion in terms of public international law, because it's not in the Vienna Convention. Of course, all our investigation or our, let's say, interest in this notion is that it's continuously recalled in legal text, in legal instruments, especially in multilateral environmental agreements. It's always there. When multilateral environmental agreements, take the Convention on Biodiversity, take the PEAK Convention, the Convention on Prior Informed Consent for certain chemicals, it's always there, either in the preamble or in the first articles of the treaty. So it must mean something. It must be there to signify something. And I'm very much in favor of inquiring into the possible legal implications arising from these statements. And of course, it's clear that we do not find a notion like that in the Vienna Convention. But of course, it can also be associated with other legal standards and principles. For example, when you think about the presumption against conflicts, the presumption against the treaty conflicts, of course, the mutual supportiveness goes in that direction to avoid genuine conflict of norms from arising. Or sustainable development, the concept of sustainable development, whatever you want to call it, the principle of sustainable development is very much focused on this integration between the economic sector and the environmental realm. And again, I think that mutual support can also be explained in terms of sustainable development. So I think that there are really legal means to make sense of this principle or notion in public international law. Of course, you didn't have much time to elaborate further here. And you, at the end of your presentation, you basically focused on what you call the lawmaking dimension, no? How it has been, in a way, incorporated in this, for example, in plurilateral and bilateral agreements, etc., etc. You of course, skipped here the interpretative dimension of mutual supportiveness, which also is very important. So perhaps I would like to hear something on that from you. and specifically about one single point here. The relevance of the general exceptions in the General Agreement on Tariffs and Trade. Everybody knows this Article 20 of the General Agreement on Tariffs and Trade. I know, and what is most striking to me, perhaps you have an answer here, which I don't have. Probably here the most relevant exceptions there are Article 20b, measures necessary to protect health, human health, and even more, Article 20g, measures relating to the conservation of exhaustible natural resources. So that would be very much pertinent. So I was really surprised that they were not invoked in those renewable energy disputes against Canada or against the US. Do you know why they were not invoked?
Yes, thank you for your questions, which is one of the things I didn't mention yet in my presentation. And I think it's good to recall, first of all, the two dimensions of mutual supportiveness, which lawmaking is the more innovative one, perhaps, is the one that allows to go forward in terms of integration, but law interpretation is the other one. And surprisingly enough, there wasn't much on that in the disputes before the WTO. And what are some of the reasons for that? First of all, Article 20b and g have not been invoked by the disputing parties. And why is that is really a wonder, because it seems quite a logical thing to do in this type of disputes. There have been some commentators that referred perhaps to the idea that the Canada-Ontario dispute, for instance, was characterized by measures adopted by the local government in Ontario. But then, of course, before the WTO, the Canadian government was the federal government to defend itself. And it was a political party that was not the same as in Ontario. So they said maybe they didn't fully make the case for their policies, which, I mean, in a way, it's counterproductive, but who knows, that might also be. And in the India disputes, instead, it was another provision of the GATT to be invoked. It was Article 20D. And they actually claimed that it was a matter of needing to comply with the UNFCCC that was what was determining the requirements in the National Solar Mission. So it was a matter of coordination with other international agreements. So it was an argument of systemic integration, if you want. However, the panel dismissed the argument there because they said that it was not really necessary to have protectionist measures like local content requirements to pursue climate goals. They said that was just an extra element, that it was more for the purpose of domestic economic policy rather than compliance with international agreements. So it remains a blind spot, and as much as the subsidy issue, which remains a blind spot as well. And apart from this, another way in which perhaps law interpretation can take place in a more supportive manner would be if WTO disputes with an environmental climate component also benefit more from environmental and climate expertise. So having recourse to experts that are familiar with concepts of environmental protection, of climate change, that can guide perhaps the interpretation of WTO rules on this matter. And this is something that is being discussed among WTO members, with the caveat that right now, as we know, the WTO dispute settlement system is not in its best moment with the crisis of the appellate body. It's not clear which future there will be. So everything around that is really moving ahead very slowly. But nevertheless, it would be something to always keep in mind, because disputes that are at the intersection between climate and trade should also be interpreted by experts that should count on expertise that are both from climate and trade. Otherwise, we remain with a legal system, that of climate change law, that doesn't really have dispute settlement systems, at least mandatory binding ones, and then disputes are adjudicated before trade panels, before investment arbitration tribunals that don't have the expertise or the capacity and sometimes the willingness to apply rules from international climate change law.
Thank you, Alessandro, for this reflection, and it actually lends it a bit nicely to an observation that I wanted to add, or to kind of throw into the mix, to hear if you had some thoughts on that, which is precisely, again, the capacity issue, right, or the people's issue in a way. And I was thinking about that not in relation to the dispute settlement which you mentioned, but also in the drafting of measures to begin with, right? Because you mentioned at some point the commitments from the countries in the NDCs, in the nationally determined contributions. And I remember, because I worked on some working paper a few years ago, precisely mapping trade-related measures in the country's first NDCs. And one thing that was interesting is that a lot of measures were related to trade, either consciously or unconsciously. And what was striking is that this was also coming from countries that maybe would then face issues in terms of their own domestic capacity, because maybe the NDCs themselves were drafted by consultants, and with maybe limited connection to the realities on the ground of what would be then the implementation of those measures. So one of the points of that mapping was precisely that there's actually a lot of scope for trade-related measures to be designed in a way that actually complies and supports the objectives of international trade law, but the extent to which it will actually happen will be a capacity issue, basically. I don't know if you had any reflections on that. Otherwise, it was more of a comment on my side.
Yeah. So I'm having some connection issue, so I hope that everything remains stable. Otherwise, just if you can't hear me or see me, but they are very much present, as you say, and there have been a wide range of policies that countries have in terms of trade and climate. One of the big issues here is also that different developed countries interest in, for instance, fostering greater cooperation of their carbon markets, in introduced to avoid carbon leakage, and these are rather following concerns of technology transfer, of making sure that they receive enough support.
Alessandro, there is something going on with your connection, unfortunately.
Beneficial to that, and perhaps also tackling limit the potential of their products. So it's really a mix of the link to trade, and but it's a very good comment that you made, and it's really very very relevant. And of course, the NDCs are constantly evolving, and the global stocktake is informing the evolution, so they will perhaps be more aligned, more streamlined, and there will be a better coordination in the newer NDCs that are adopted by Paris Agreement parties.
Thank you, Alessandro. I think that we had some problems at the beginning of your answer, but then things got better again. So at least that was my impression, Riccardo. Yeah, I see that there are no questions at the moment in the chat, so I don't know. Riccardo, do you have an additional point? I also have a little bit of an open-ended question for Alessandro. We have, let's say, 4 or 5 minutes left, so please go ahead if you have something yourself.
my next point would be about the disputes about biodiesel, biomass, because there is a section on the book also describing and commenting on these WTO disputes between the European Union and several WTO members, especially Argentina and Indonesia, if I well recall, about anti-dumping measures adopted by the EU against imports of energy made from biomass. So I think that, of course, if I well understand, of course, you please correct me, Alessandro, if I'm wrong here. The WTO bodies found that those EU measures were violating the anti-dumping agreement, but rather on technical grounds, because the method of calculation of the anti-dumping was incorrect, etc. So I think that I'm really looking forward to a dispute where indeed we are talking about the merits of measures taken in the realm, in the area of energy made from biomass, because I think that is the most controversial technology here. And you underline that in your book. And I also, I really learned that there is a need here to distinguish between the different sources of renewable energy. One thing is solar energy, another thing is energy made from biomass here. Do you think that a different approach may ensue here from WTO bodies or in the next trade disputes here?
Yeah, thank you for this question, because indeed it is important to differentiate between renewable energy sources, because renewable energy is a big container ultimately that has a lot of different technologies inside, some more developed, some emerging, and some more sustainable than others. And we are pretty much, there is consensus, let's say, that solar and wind are sustainable sources, although not always. Also in that case, like wind energy, placement of turbines in a way that is consistent with biodiversity, that is also sometimes a discussion. But generally speaking, the emissions of the technology are rather low compared to the energy they generate. So they are classified as climate-friendly technologies. Bioenergy, it depends. It really depends. And actually, the disputes that I mentioned in the book, they are rather about the subsidy and support of these technologies in certain countries. So here the European Union applied duties that were found excessive. So yeah, rather technical. But there are some new disputes that came after the book, and they deal with the methods used by the European Union to calculate the emission savings of bioenergy technologies. So especially the so-called ILUC criteria on the indirect land use change, which is something that the European Union has very much focused on, and they adopted specific and technical regulations differentiating which bioenergy sources are better for ensuring that there is no competition with agricultural land, that emissions are actually reduced. And as a result of these calculations, some technologies like palm oil and the production of biodiesel from palms has been very much penalized compared to producing bioenergy from waste or even certain crops. So this, of course, is a regulation that is technical, but it ends up creating different conditions for some countries like Indonesia, like Malaysia, which are big on palm oil. And it's not by chance that these very countries brought disputes to the WTO against the European Union, challenging this regulation and saying that the ILUC calculation methodologies are essentially not based on scientific data, and there is no clear link with the climate change impact and emission savings potential of this. And as far as I recall, the disputes are still pending, also because of the backlog of the panel now with all the disputes in general. But if not, if I'm mistaken, then maybe I will check immediately if there have been new developments. But some months ago, they were still pending. But it is definitely, it will be an issue where the panel will have the opportunity to specifically make a decision on the climate potential of these measures, and not only on the, let's say, more economic aspect of it. So it is a very, very good point, and important to keep an eye also on this development.
Thank you, Alessandro. So I see we are just passing the 1 hour mark, and there were no further questions from the audience. So I don't know if Riccardo, do you have some concluding thoughts? I had some questions of my own. I will ask Alessandro after, I guess, since we are trying to stay within the mark. But Riccardo, if you have some concluding thoughts, also because, as you said, this is the last webinar of our series, so perhaps it is worth it also to add something here.
No, I don't want to add any further, because we promised that we keep this to 1 hour, and 1 hour must remain. We've always been very punctual in that regard. So I think that we already said what we are going to organize in the next few months, actually until the end of November. My final thought is again to thank Alessandro for being with us. It was really interesting to me to discuss live some of the themes of his book, because his book, of course, is more much there is many more topics that would be that could be discussed. So thanks again for being with us, Alessandro, and I hope we will have further occasions for collaboration in the future.
Thank you both very much for inviting me, and it's been really a pleasure being here. And best of luck for the final event of the series. I am sure it will be big, and I look forward to participating as well, joining that event at the end of November. So, and well, thank you, Dario. Thank you, Riccardo, for making this possible. And I hope that you will, for the audience, that maybe some of you will be interested in the book after this discussion, and it's available on Edward Elgar's website, of course. And otherwise, just thank you so much, and let's stay in touch.
Thank you, Alessandro, also from my side. And yes, indeed, let's stay in touch. And by everyone who's been watching, we're happy to host this new webinar.
Let's just repeat that the webinar is available online.
It is as usual. It will stay there, and of course, if you have questions after watching it again, also please do feel free to be in touch with either Alessandro or ourselves with the contacts that you will find online.
Absolutely.
Thank you very much once again.
Thank you. Bye-bye.